it is important the public understand why a particular sentence is being imposed. This case should be called to the attention of all young people who have just passed the driving test. It is a case of a young man, aged 17 as you were, driving a car deplorably, almost certainly trying to show off to friends. In consequence of driving too fast, that young man, you, killed a friend and maimed another friend. A young life has been ended. Another 2 lives have been ruined. For what? Showing off to friends. Immaturity on the grand scale. Corey Owen Cooper, you are aged 19 years. You were aged 17 years when you committed the 2 very serious crimes for which you fall for sentence this afternoon. I have your young age well in mind when reaching my conclusions. You have no previous convictions. That too is a very important matter. You pleaded guilty to 2 crimes at the plea and trial preparation hearing, namely causing death by dangerous driving and causing serious injury by dangerous driving. These crimes were perpetrated by you on 11th November 2023, almost 2 years ago. The incident occurred at approximately 11 p.m. on Myers Grove Lane in the Stannington area of Sheffield. By reason of your guilty pleas and the stage at which they were entered, the inevitable sentence of custody may be reduced by 1/4 by reference to the guideline of the Sentencing Council on the subject of guilty pleas. I have considered the submissions that you are entitled to a higher level of credit. That submission, in my view, was misplaced. There was no unequivocal acceptance of guilt in the court below. There are, however, other, much more important and potent submissions which have been made on your behalf. The 2 victims of these crimes were Joshua Atkins, aged 17, who was killed, and Gabriel Wiggett, aged 17 years, who was grievously injured. They were both friends of yours. I have listened with great care to the moving personal statements read to me this afternoon. By your criminal conduct, you have wrecked the lives of 2 families of the victims of this crime, as well as wrecking the lives of your own family. I must make it clear to you and to everyone that the sentence I shall pass in this case in no way reflects the value of the life of the deceased. All human life is of infinite value. This is not a case of murder or manslaughter, but it is a very serious case involving the death of one human being and very serious injury to another by your criminal conduct connected to appalling driving by you. This case depicts human tragedy in every dimension. By your criminal behavior, you have shattered the lives of many people. You have wrecked your own life. You are responsible for the death of your friend and the very serious injuries caused to another friend. The features of the case may be encapsulated by these points. 1. You were a very inexperienced driver. You had passed the driving test the day before these crimes were perpetrated. 2. The Fiat Punto motorcar belonged to your grandfather and he lent it to you. You were properly insured to drive the car. 3. Unfortunately, the car suffered a braking malfunction and the warning lights were illuminated for approximately 90 minutes. Whilst you were driving around, you ignored those warnings. 4. The failure of the ABS braking device did not, in the result, impact upon the incident itself. It is not causative of what happened. 5. The reason for the collision with the post was simply you were driving far too fast on a narrow country lane. The speed limit is 20 miles per hour, and you were driving in excess of 50 miles per hour shortly before the impact. Indeed, 480 meters before the collision, you are assessed as travelling at 53 miles per hour. It is right to observe you applied the brakes and then oversteered in the way described in the experts' reports. It is plain you had spent most of the evening showing off to friends about how fast you could drive the car. At one stage before the fatal events, you were doing wheel spins in a car park. One of your friends, a young woman, was so concerned that she did not feel safe whilst being driven by you. When she wanted to be taken home, she switched cars to a friend who was ultimately travelling behind you. There can be no doubt your criminality warrants a sentence of immediate custody of some substance for your truly appalling driving. Notwithstanding, it is important I keep a sense of proportion and perspective. I turn to the facts. On 10th November 2023, you passed the driving test and had a full licence. On 11th November 2023, one day later, you killed your best friend and seriously injured another friend by your deplorable driving on Myers Grove Lane at Stannington in Sheffield. You were driving a Fiat Punto motorcar which belonged to your grandfather. You had his authority to drive it, and you were insured to drive it. You spent the evening with friends, driving around from one place to another. You first drove to Josh Atkins' house to relax with him and other friends. Later that evening, you went around the local area with Josh Atkins, Jack Ranby, and Lily Donaldson. Lily Donaldson describes you as driving far too fast when she was in the car. At times it was thought between 60 and 70 miles per hour. It is thought that when you were driving past Bradfield School, you reached speeds of about 80 miles per hour. Whatever the accurate speeds were that evening, you were repeatedly and regularly driving far too fast in all the circumstances. It is observed by one of the passengers that you nearly lost control of the car going round a bend earlier in the evening. It is also recalled by other passengers that the dashboard warning lights were illuminated, and that is revealed from the material I have seen this afternoon. You ignored the warning lights. Lily Donaldson was so concerned about the manner of your driving that she messaged her boyfriend, Lewis Haig, that she did not feel safe in the car. He was out that evening in his car, driving at times in convoy with you. At any rate, you met up at Stannington Park, where Lily Donaldson got out of your car and transferred to the other motor car. From there, you drove up to Redmires in the Lodge Moor area of Sheffield. You spent some time relaxing with the others in the car park, but it is right to observe that you were showing off yet again, doing wheel spins in order to endeavour to impress your friends. In reality, it is comprehensively unimpressive. One of your friends was then taken home. You then went to a Morrison's car park in Hillsborough. You stayed there for a while. You then picked up Gabriel Wiggett from a side road near Middlewood Park. It was then agreed that the two vehicles, yours and your friends, would be driven to the car park at the end of Myers Grove Lane. That lane is a tree-lined, narrow, single carriageway, in effect a country lane, at Stannington in Sheffield. The speed limit is 20 miles per hour. There are signs intermittently along the road to reveal the speed limit. The road is approximately 760 metres long. After the vehicles arrived at this car park, Josh Atkins and Gabriel Wiggett got out of their car and Lewis Haig got out of his car. They stood by the vehicles talking whilst Lily Donaldson remained in the vehicle. After about half an hour, she wanted to go home. It was approximately 11 p.m. You all, that is to say 5 of you, got into the various cars. Lewis Haig and Lily Donaldson got into his car, and the other 2 got into your car with you driving. Joshua Atkins was the front seat passenger. Gabriel Wiggett was the rear seat passenger behind Joshua Atkins. As your car was parked in front of Lewis Haig's vehicle in the car park, you set off first. Lewis Haig's car was behind. Both cars were driven round the first bend on the way back at approximately 30 miles per hour, which in itself was way above the speed limit. It is at that point you drove dangerously. You accelerated fast. You were driving far too fast. You pulled away from the other car, and then as another bend came upon you, you lost control of the car and collided with the metal fencing. The consequences were devastating. Joshua Atkins died rapidly of brain and spinal cord injury incompatible with life. His parents behaved with remarkable magnanimity in permitting the doctors to use some of his organs for transplantation purposes. They are much to be congratulated and admired for that act. Gabriel Wiggett was seriously injured. He sustained a number of very serious injuries, including a pneumothorax and various other lung injuries. He had fractured ribs, and there were fractures of his spine. He was in hospital for some time, but perhaps rather more important than his physical injuries are the psychological and psychiatric problems that have developed as a consequence. He is still seeing a consultant psychiatrist. There is agreement in relation to the guidelines of the Sentencing Council in terms of the crime of causing death by dangerous driving. The case falls within culpability category A without question, where there is for an adult a starting point of 12 years imprisonment with a range of 8 to 18 years imprisonment. You took a deliberate decision to ignore the rules of the road, and you were significantly in excess of the speed limit when driving that motor car down that lane. There are aggravating features in the sense that serious injury was caused to another person. The deceased was indeed a passenger in your car, and you were a very new driver, driving a motor car egregiously. There is mitigation, however, and I shall turn to that mitigation in one moment. But I repeat, you are of good character, and I have well in mind your age. In relation to the other crime, it is agreed the case falls into the category of A2, where there is a starting point of 3 years and a range of 2 to 4 years. I shall regard the lead sentence in respect of count 1. I have read the pre-sentence report about you. I am indebted to Miss Dower, and so should you be, for the submissions she made on your behalf. They were helpful and realistic submissions. It is unnecessary for me to go through every single item of mitigation in detail, but I have it all well in mind. I have already indicated how your guilty plea will be dealt with. Although it was argued to be right at the lower end of the range of category A, that is a submission I cannot accept, but Ms. Dower was right to argue that the case falls below the starting point. There are no other serious aggravating features. I have that well in mind. For example, you were not drinking and driving or taking drugs or anything of that kind. It is very important when I apply my mind to all the guidelines in this case that I do not adopt a formulaic or mechanistic approach to sentencing. I must exercise judgment. The sentence must be tailored and fact-sensitive. Your good character is of importance, including the fact that now it is lost, it will take a long time for you to recover your good name. I have well in mind the submissions made at paragraph 22 of the written submissions of Miss Dyer, to which it is unnecessary to make public reference. I have that well in mind when reaching my conclusions. Your remorse is genuine. The victims were close friends. Your age and lack of maturity is borne very much in mind. In this regard, I have paid close attention to the guidance of the Sentencing Council in respect of sentencing youths. Your lack of maturity, your lack of the appreciation of the consequences of your actions are features I have well in mind. Your emotional maturity is also limited. Your thinking skills, like a lot of young men of your age, I regret to say, are limited. I have that well in mind and will make an appropriate and substantial reduction in sentence because of that factor. There is also delay. I note your family support. I have read all the letters, including your letter. The simple fact of the matter is, in the ordinary course of events, you are a thoroughly decent young man, as were the two young men who were the victims. But you are the one, I am afraid to say, who must be punished. I make it plain that I have the principle of totality front and centre of my analysis in terms of sentence. This case demands the exercise of judgment and the application of various guidelines to which I have made reference. I repeat, it is necessary to keep a sense of proportion. It is, however, equally important to remember a young man has been killed. Another young man has had his life adversely affected. Those two young men, one now dead, the other badly affected, have been put in that terrible state because of you. But equally, your life has been affected by your own criminality. Pulling these various strands together, I have therefore reached the following conclusions in relation to sentence. It is important I set out my analysis briefly but clearly. Had you been an adult and following a trial absent any mitigation, each of these counts standing alone would have warranted the following sentences. On count 1, 10 years. On count 2, 3 years. I cannot simply commence my voyage to find the right result by adding those two figures together. The principle of totality obtains. It is therefore my judgment that following a trial, had you been an adult and absent any mitigation, a sentence of 11 years would have been imposed upon you. By reason of your age, when you perpetrated these crimes, it is my intention to reduce the sentence before making any further reductions to one of 7.5 years. by reason of the personal mitigation in this case, which is important, but in the context of this case cannot overly affect sentence, I propose to reduce the sentence further to 7 years. It is at that stage I make the appropriate reduction for your guilty plea, which brings the case down to one of 5 years and 3 months, purely as an act of mercy. And I emphasize, purely as an act of mercy. I will round that down to 5 years. The appropriate sentence, therefore, in this case is detention in a young offenders institution for 5 years. I intend also to disqualify you for a period of 5 years. There will also be an extended test order. Accordingly, in terms of the individual sentences, they are as follows. On count 1, 5 years detention in a young offenders institution. In respect of count 2, which will be concurrent and is taken into account in any event in reaching the figure of 5 years, I pass a sentence of 18 months detention in a young offenders institution. There will be a disqualification for a period of 5 years. Certain calculations now have to be undertaken before I formally pass sentence upon you. Mr. Dyer, it's just occurred to me that given the 18-month sentence, I don't think I can actually impose an 18-month sentence. It has to be a detention and training order, I think. And therefore, on that basis, what I'm minded to do is indicate that would have been the sentence, but actually impose no separate penalty. Otherwise, it becomes unnecessarily complicated. Do you dissent from that view? I've signalled what it would have been, pure and simple, and had it just stood alone, it probably would have been an order of the kind I've mentioned, but it doesn't stand alone, and therefore it has to be the 5 years. I think that's the sensible way, don't you?
My Lord, yeah, the cleanest way.
It is the cleanest way. Don't you agree? Very good. Well, then the technical sentences will be as follows. 5 years in respect of count 1, no separate penalty in respect of count 2, but let there be no misunderstanding. Had it been able to be sentenced, but for very technical reasons, it's not going to be, there will be no separate penalty, but had it been possible, it would have been a sentence for 18 months. I do not want the victim in count 2 to run away with the idea that in some way the court has overlooked his serious injuries. Far from it. I have very much taken them into account in respect of the other sentence, which I indicated was the lead sentence. Therefore, what is the necessary calculation in terms of disqualification before I formally pass sentence upon him?
My Lord, with a 5-year disqualification...
and a 5-year sentence?
Yes, less 80. Can I just have one?
Yes, of course you can. These calculations are very difficult to do, and I'm sorry you're having to do them at some little speed. Let me explain the situation to you whilst the lawyers are doing the necessary calculation. Parliament has set out a rather complicated system, unfortunately, for the calculation of the period of disqualification when a person is sent into custody. It has to take into account a whole range of factors. It is all designed so that the period of disqualification of 5 years locks on at the point you are released. And the lawyers at the moment are doing the necessary, rather difficult calculation, and that's why we have to wait, I'm afraid. I wish it were otherwise, but it isn't. Yes?
My Lord, if you will agree that we've made an adjustment of the 88 days for the interim disqualification...
Yes, of course.
...to 3 months, simply to make the figures make sense...
Yes.
Then the disqualification, my Lord, passes as one of 7 years, 3 months.
Very well. So the extension period is 2 years, 3 months. So it's 5 years plus 2 years and 3 months, total 7 years and 3 months, which starts today, so to speak. Very good. Are there any other matters that I've left out of account that need mention? I don't think there are, but if there are, now's the time to do it.
Not from the defence, my lord.
Thank you very much. Thank you very much indeed. Would you stand up, please? As I said to you a little earlier this afternoon, it is a terrible thing for a judge to have to send someone like you to prison, but you have committed serious crimes, including causing death by dangerous driving. I have set out my full reasons as to why I have to send you into custody, and I appreciate fully how hard that will fall upon you. You are being punished. Of that, there is no doubt. The sentence I pass upon you, therefore, is one of 5 years detention in a young offenders institution. I pass that sentence upon count 1 for entirely technical reasons. I impose no separate penalty on count 2. Had it stood alone, there would unquestionably have been a sentence of at least 18 months detention. I disqualify you from driving for a total period of 7 years and 3 months, made up of the primary disqualification period of 5 years, plus an extension period of 2 years and 3 months. There is an extended test order. You will remain disqualified until such time as you pass the extended test. There will come a time when you are to be released from custody. If you breach the terms of your licence, you may be recalled. You must now go with the officers.